morning. Happy New Year. Welcome back to Law Power Hour. I hope everyone's inside today. If you're not inside today, go in and bring somebody in from the outside who can't get inside. Give them something to eat. Make sure they get home okay. I had 2 people show up my office on Thursday and Friday. They didn't have a place to stay, no food. So I drove them home myself, made sure that they got to their families and made sure that they had food. So let's get a little cooperation out here and help the people who are homeless and who can't afford to go out and get food, and make sure they have shelter, because we are all blessed who do have a roof over our head and a bed and a pillow to sleep on at night. In that regard, we're blessed and fortunate to have David Cripps with us today. David, thanks for coming.
Barry, thank you very much for inviting me to your program. It's a pleasure to be here.
You know, you have a history of handling literally thousands of cases and trying over 1,000 cases in the state of Michigan as a criminal lawyer. And my hat's off to you, because you are a vigorous advocate. Tell our people a little bit about you and your firm.
Well, thank you, Barry. I first started out doing criminal defense work in the 1980s at the Public Defender Office, known then as the State Defender Office, and gave the best advocacy I could for the people who couldn't afford lawyers. From that point, I then left the office and joined other lawyers in private law firms. And for the last 30-plus years, been doing nothing but criminal defense work. Currently, I'm practicing with my wife, Gabi Silver, at Cripps & Silver, and we do a lot of high-level criminal defense work, and along the way also do pro bono work to help the people out who can't afford lawyers.
And your wife, she's unique. I practice with my wife, Anne-Marie Paramount. We do civil litigation, and I'm sure her reputation precedes her. As I've heard in the community, that she's tenacious, she's very tough, and quite an advocate on behalf of her clients. So you should take your hat off to your wife, and I take mine off to my wife, because she's a tough hombre when it comes to civil litigation. So we're both very fortunate. Now, where do we find you?
Well, our law office is right near the criminal justice system in Detroit on Gratiot Avenue, right near Frank Murphy Hall of Justice, in front of 36th District Court. We're right on the first floor, and where our doors are open to anyone that wants to come in to discuss legal problems that they have.
Now, I'm going to get a little sarcastic, and I'm going to ask you, where are you going to move your office if Gilbertville takes over that neighborhood?
Well, we're going to stay right where we are. There's great access to the community there to find us easily, and wherever they decide to move the criminal justice system, we'll travel there, but we're not moving our office.
Okay, now in terms of the criminal justice system, one of the problems that I deal with because of this show is that I get a lot of people who call me who unfortunately can't afford lawyers, and they go into the criminal justice system and they have to have court-appointed lawyers. And you're aware of this. You've dealt with this. Public Defender's Office can only handle so many individuals who can't afford the services of a lawyer, and the legal aid can only handle so many individuals who can't afford the services of lawyers. So the justices in the criminal system appoint lawyers to handle cases. That's true, isn't it?
Yes, it is true. And it is one of the, I guess, beliefs in the criminal justice system that is the truth. The reality is you do get what you pay for, and obviously high-powered lawyers who get paid a lot of money have a better success rate than others. However, there's a few of us in the community who believe that even though we get retained on many cases, have a obligation to the community to also do pro bono appointed work to assist those who can't afford retained lawyers otherwise.
And I know you and your wife do pro bono work, and by pro bono work is that you do assess cases and take cases on for individuals who can't afford lawyers, and I don't know how you make decisions as to which case you're going to take, because you can't take every case that you get a call on. I mean, if somebody's picked up for driving under the influence of alcohol, you can't afford to take those pro bono cases if there's another individual, for example, who is being charged with first-degree murder. So you've got to make some intelligent professional decisions. Isn't that true?
Absolutely. A lawyer has to learn. You have to have a screening system as to what cases to take. And if it's someone who, a grandmother comes in and makes a passionate plea regarding her grandson or granddaughter, or something might have some political overtones to it, then my wife and I are very open to helping that sort of person. But you're right, Barry. You have to screen very carefully as to what type of cases you're going to take a client on for.
Now, the other difficulty in terms of being a practitioner is that when people retain you, they make a lot of promises to you about paying you. So it becomes very difficult when you're locked in a case. And listeners have to understand this. We write our own checks out here. No one in the big law firm's writing David's check or my checks. And when you write your own checks, if you retain a lawyer, you've got to make a commitment to that lawyer to pay the lawyer for the services, because they can't opt out of a case professionally. Once you're in a case, you just can't say, I don't want to go any further with this case, can you?
That's right. The time we spend on a case is our monetary value. There's no doubt about it. In addition, as I have to explain to my clients quite often, is none of what we do in the criminal justice system is free. There will be, in any case, involves acquiring discovery materials, all of which we are charged with from the prosecutor's office to receive. We have to make multiple court appearances. If our clients are incarcerated in the jail, we have to make obligated and should make jail visits. And all of that is very time-consuming for any individual lawyer.
Now, would you agree with me that the most difficult part of practice has to do with communication?
Absolutely, Barry. You couldn't put your finger on something more important than communication, not only with the client, but also the client's family. Most misunderstandings that I've seen over the years that clients come to me dissatisfied with the lawyers that they have has to do with a lack of communication. I believe it's the lawyer's responsibility, not only with the client but the family, to sit down, explain what they're charged with, explain the possibilities that they face down the road by going to trial and losing, or to enter into plea negotiations in a form of damage control in terms of plea negotiation, and go over all the ramifications that sentence guidelines hold and sentencing consequences.
You know, I can remember years ago, I had a case, and as I told you, I do very little criminal work, but this was a young lady who was part of an extended family I represented for 30 years, and she was charged with delivery of crack cocaine. So we worked an arrangement out for her because it was her first defense. And all of a sudden I get a call from a city outside Detroit. I won't identify the city because they may identify the basketball player. But he was an NBA player, and it was his daughter from a relationship that he'd been involved in, and he wanted to step in. And I said, well, how much time do you spend with your daughter? Well, she called me. I haven't seen her in 5 years. I mean, we want people who are actively involved, is what I'm trying to say. You hit it on the head. If somebody in the family is going to be charged with a crime, or somebody is going to be prosecuted for a crime, or even going to be sentenced on a crime, you want the family involved, don't you?
Absolutely. You have to have the family involved in the case. They're the ones that provide the backbone of the emotional support for someone who's in serious legal problems. They're the ones that provide the financial background, and they're the ones that can explain the circumstances that may have led up to someone's involvement, whether it be narcotic problems or domestic problems or financial problems that cause someone to commit a crime that they wouldn't otherwise do.
So if I understand you correctly, if you have a client, you don't want your client to walk through this alone, do you?
No, you don't.
Okay.
You don't at all. It's and that's a lawyer's responsibility to not only provide legal support, but also guidance on how to get to the criminal justice system. It's very difficult once you get charged with a crime to understand the dangerous things that can happen down the road, whether it be incarceration, restitution, which is monetary damages that you may have to pay back to a complainant. All of these things take a lot of explanation and support for someone to get through it.
Now, the reason we're educating you on all of this at the beginning of the year is, unfortunately, our crimes have not gone down. Our murders have gone down, but our crimes haven't gone down, have they?
There's a dispute about murders going down. Sometimes there's a suggestion that people play with numbers. The calls I get in relation to homicide charges have not gone down. But crime seems to be a steady thing, and I think it's a result of people's response to economic circumstances and other changes in government policies. I've just read that the administration in Washington has taken a major change in how they're looking at marijuana prosecutions nationwide. As we know, the federal laws are far different than various different states in terms of marijuana prosecution, and it seems to be a sea change in terms of how the United States government is going to look at in terms of an aggressive prosecution now of marijuana in the people involved in the marijuana business.
And beware, and I say beware, if you're in the process of immigrating to the United States and you are charged on a marijuana charge, you will be deported because the United States government Immigration and Naturalization Service has a different standard than the Michigan State courts. So beware, if you have a conviction of marijuana possession, delivery, anything that's related to driving under the influence of drugs, you're running the risk of being deported.
It's interesting you bring that up, Barry. That's a very, very important issue to discuss with any potential client. When there's a guilty plea in court, the first thing a judge will say, are you a U.S. citizen? I suggest that us lawyers do the same thing when clients come in the door. Are you a U.S. citizen? Because what may look out to be a perfect plea deal for someone who's a U.S. citizen, where the conviction would go away after a period of probation, that is not true for someone who is not a U.S. citizen. Even though it may be like a diversion where the case is dismissed, if you're not a U.S. citizen, it still could result in you being deported from the United States. That's a big concern that every lawyer has to address.
Well, additionally, I think what's important, and I want you to explain this, about the global effect on a person, and I'm talking about the person being a universe unto themselves. When I use the term global, I'm talking about how it affects every facet of their life if they have a conviction, from immigration status to employment status. Would you just go, through this process? Let's say I come into your office and I have a problem. I'm charged with felonious assault because I'm a hothead, and I go into a bar and somebody makes a smart remark to my wife and I hit him with a beer bottle. Now, the fact that I'm a lawyer isn't going to protect me, is it?
No.
Okay.
It may put a target on your back, in fact.
Yeah, civilly, it's going to put a target on my back, okay? But at age 75, I'm not going to go around hitting people with beer bottles. I'm going to get somebody else to do it, but that's okay. Setting all that aside, if I get charged, the ramifications are enormous, aren't they?
Yes. First of all, a felonious assault is a 4-year felony conviction. So the first concern any person should have is, if there's a conviction, am I going to prison? Beyond that, there's other ramifications that even I have to explain to my clients, even if we're able to work out a term of probation. And what probation is a sentence outside of jail or prison where you would report to a probation officer. That has ramifications too. You'd be under the oversight of a probation department.
Hold on for a second. Someone's calling in here. Good morning. Hello.
Good morning. Good morning.
How are you doing?
I'm doing just fine, Brother Barry. This is Ordinary Joe. And all I want to do is call in and wish you and your guests a very, very happy new year and many, many more. And I want to thank you for choosing to do advertisement on TV 33 WHBI.
Thank you, sir.
Officially, you have become Brother Barry. Thank you for taking my call.
Thank you. Okay, let's get back. And Joe, you're appreciated. To our story. So here I am. I'm a lawyer. I'm using this specifically so that you can explain how it would impact on me as a lawyer.
As a lawyer, we have the privilege of being a member of the state bar, and if there was a felony conviction or any type of conviction, you would face ramifications from the state bar as to possible loss of your license, possible reprimands, possible other considerations that someone with a professional license would face. So I have represented lawyers before on criminal matters, and it's a whole separate universe in terms of protections we'd have to take to avoid any loss or infringement upon your license to practice law. So that'd be the first thing we discuss as a lawyer.
Now let's say I take a plea, okay? And I'm guilty. And I take the plea, and I've got to go on probation. I've got to meet with a probation officer and show up according to schedule, right?
Yes.
Okay. And as a general rule, if you're in the four-county area here, if you're in Wayne, Oakland, Macomb, or Washtenaw County, and I just use that as an example because that's within the 50-mile radius of where we're at, you're going to have to drop every time you go there, aren't you?
Yes, that's fair. One of the conditions of probation often is that you have to do a urine drop where they can see whether you're using marijuana, cocaine, heroin, or any other illegal narcotics. Other ramifications of probation is if there's a restitution issue that you have to pay money back to the complainant. They're going to keep you on a regular payment schedule. If you get off that payment schedule, you could be violated on your probation by the judge, which you could end up in jail.
Now, let's say I get a ticket for driving under the influence of alcohol because I start drinking afterwards because I'm so upset about the stupidity of my actions and I lost my license to practice law. I can be violated my probation, can't I?
Yes, you can, and violation again means you could be sent to prison or jail or have your probation extended. If you have a probation for a term of 1 or 2 years, the judge would say, I'm going to extend your probation. Could be all the way up to 5 years for a felony conviction. I'd like to add there's other ramifications of a felony conviction too, as you can't run for public office, you can't vote. So these are very important privileges that we have in our society that you also lose by having a felony conviction.
You can't get credit. These are all
You
important.
can't get credit.
Right.
And it also you can't get certain licenses, such as a nurse or any other license in the state of Michigan. A felony conviction can prevent you from doing that.
Now, let's say I go through the whole process and I'm rehabilitated. I paid restitution, but I'm also subject to being sued, aren't I?
Yes, that's a whole separate consideration that we have to take into account as criminal defense lawyers, is that you also can be sued civilly. And in fact, there's a type of guilty plea known as a no contest plea, or nolo contendere, made famous by Spiro Agnew in the past, where it's a form of guilty plea, but you don't have to admit your guilt on the court record, and that's the acknowledgement that many people are sued civilly even after a criminal case is over with.
Okay, we're going to take a break, and I know that normally we take breaks at every 15 minutes, but I want to get into the sentencing aspect of this, and we're going to use this hypothetical so that our listeners understand the whole process. Because I know when people come in your office, you explain the whole process to them, don't you?
Yes, we do, from beginning to end.
Okay, see, now that's what's unique about his services and his wife's services. They explain the whole process. You get the whole process up front. When you get a lawyer appointed appointed lawyers, they don't sit down and explain the whole process, do they? Let's be
Well-
fair.
Well, to be fair, there are some very good appointed lawyers, but there are some who don't take the time to explain like they should to everyone involved in who's being charged with the crime and their family, the overview of the criminal justice system as to what happens to someone from beginning to end. You're right about that, Barry.
See, that's one of my biggest pet peeves about court appointments. When people go into the system and they don't get an explanation and they enter a plea, they don't understand the ramifications. We're going to get back in a minute and we'll talk about it.
Look forward to that.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Using me as the example, you can call me the guinea pig, it doesn't matter. But I think it's important to reflect through me what can happen to me as a professional. And let's go to the next level. You come to me and say, Barry, they've got a ironclad case against you. They've got 4 witnesses in the bar, and I can get your plea. You'd offer me that kind of arrangement, right?
I think it's the duty of a lawyer not only to prepare for trial, but also to investigate plea negotiation. It'd be irresponsible otherwise.
Okay, so we get a plea to my assaultive behavior. And I've got a beer bottle in my hand, so I've got an assault with intent to do great bodily harm, right?
Possible.
Okay. And because I should know better as a professional, no one's going to give me a break on a plea.
That's also possible.
They're going to hold me to a different standard professionally, right?
Yes, I think the prosecutor's office, in their massive ability to use discretion as to who should be charged, who shouldn't be charged, and what they should be charged with, a lot of it has to do with who is the person they're looking at in terms of the potential defendant. And a lawyer, obviously, they look at a lot more carefully than someone who's not a lawyer.
And we want you to understand, this is important for the community to understand, that we're not immune to prosecution. We would be held to a higher standard. And because we're in a position to make decisions, we know what we're doing. We're out in the public and should behave appropriately, correct?
That's correct, and we've seen a lot of recent prosecutions of lawyers involving violation of public trust and fraud cases. And I think if someone is a lawyer, I believe whether it be the U.S. Attorney's Office or the local prosecutor's offices take an extra special look in applying a higher standard to an attorney or a doctor than they would someone who is not so licensed. Sometimes I take issue with that because I think it's an unfair standard to put a professional to in terms of what a doctor may have to face or a lawyer have to face in making tough decisions on any given situation they're involved in. I once represented an emergency room doctor who was trying to save his brother from alcoholism and had to keep him from getting to the liquor bottle, had chained him up and at his house because they couldn't get him into a treatment program unless he was sober. And during that short period of time, unfortunately, his brother either took his life with the chain around his neck or got hung up on the stairway with the chain. My client was charged with manslaughter. And I think the prosecutor's office held him to a higher standard because of the fact that he was a doctor and should have known better. Ultimately resulted a ruling in his favor, but he had to go to a great deal of expense and emotional trauma to get there.
Okay, so I get a plea offer. And I say, well, okay, what's the plea offer? Maximum sentence is 4 years? Is that what you told me?
Yes,
Okay, so I could get from 0 time to 4 years in jail, right?
that's correct. Even if you do get probation, Barry, as opposed to prison time, the judge also has the option of giving you some jail time in the local jail as a condition of probation. That's something that some lawyers overlook in their plea negotiation, is the judge has the option of giving various sanctions such as jail or mandatory treatment in a alcohol drug program, or even workforce or community service are all sanctions a judge can use if someone is given probation.
Am I entitled to get a preview of what my sentence is going to be if I plead guilty? Can we ask the court to tell us what the sentence is going to be?
Yes, a number of years ago, the Michigan Supreme Court issued a case of People versus Cobbs, C-O-B-B-S, Cobbs, where if the negotiation breaks down between a defense lawyer and the prosecutor's office and they're unwilling to make a plea offer, or it's just the type of prosecutor's office that won't make a plea offer, the defense can ask any given judge we're assigned to for a Cobbs evaluation. That means the judge will tell the parties, this will be my sentence if you enter a guilty plea. It's to take the surprise and shock out of a sentence someone may receive and let you know ahead of time so you can make the appropriate decision. The judge, a lot of what the Cobbs evaluation is based on is whether someone has a criminal history, whether they have an extensive criminal history, the nature of that criminal history. Also takes into various factors as to what we call offense variables, the extent of the injury that the complainant may have suffered, were there other people placed at risk. All these are taken into the whether someone's employed. All these are taken into account in the sentencing scheme, and the judge can say, this is my Cobbs evaluation if you enter a guilty plea.
Okay, now, what's important, and please explain this, and listeners, if you're out there and you don't understand it, call in and ask questions, because this is the most important part of the plea process. Should you wait on taking your plea and adjourn the plea date until there's an opportunity to get a Cobbs assessment from the judge?
Absolutely. It takes the uncertainty out of a system that is very uncertain. I never overlook how the ramifications of that it has on someone, both emotionally and the family's emotional stability, to be charged with a criminal offense. And the uncertainty of what someone may face. Am I going to prison? Am I going to jail? What's the economic effect on my family? A Cobbs evaluation, the judge can tell you right up front as to what kind of sentence you'll receive. And I try to do that as quickly as possible, Barry, because someone with a charge hanging over their head can't get callous to the fact of how that can affect them emotionally.
And here's the point I'm trying to make. Would you agree with me? If it's a first offender, first time through the system, you don't want them to go through the system alone, do you?
No, you don't. And I have a checklist in my mind for first offenders, because there's various sentencing options that you can save someone from having a felony conviction that are available.
Now, a lot of you live with other family members other than your mom and dad. We get calls oftentimes. Grandparents call in about the children. Aunts and uncles call in about nieces and nephews getting in trouble. So listen to the checklist. It's really important. Go ahead.
Well, first thing I look at is the age of my client. If my client is younger than 24 years old, there's something known as HYTA, H-Y-T-A, Homes Youthful Trainee Act, that was passed a number of years ago, where if someone is HYTA eligible, there are some exclusions depending on the nature of the crime. It means the conviction is wiped off your record as if it never occurred, right at the time of sentencing. And if there's not a violation of HYTA, it keeps you with a clean record. It not only affects someone's ability to get a job, but HYTA protection also allows, if some young person wants to go to college, you can't get federal financial aid if you have a felony conviction. So HYTA is very important for every lawyer to take a look at. There are other diversionary type programs, and diversion is a program. Wayne County has a diversion program, some counties don't, in which a first-time offender on a certain number of offenses can be separated from the legal system, that's why it's diverted away from the legal system, to have their case dismissed against them as long as they take the steps that the prosecutor's office wants them to. There's also other types of pleas under advisement, domestic violence field and other areas, where a special type of probation is wiped off your record after you satisfy terms of probation. So these are things that are very important for a lawyer to look at to see if their client's eligible for that when you're investigating a case.
Okay. Most of those are expungable with the exception of domestic violence, correct?
Yes, that's correct.
So if you're involved in domestic violence issue, you're not going to be able to get that off your record. And if you have a second domestic violence, goodbye. You're going to spend some time in jail.
Area of drunk driving has that problem too in
Right.
terms of expungement.
And driving under the influence of drugs also has that problem.
And criminal sexual conduct offenses too.
Okay, so we've given you some baselines there as to what types of offenses are not dischargeable with expungement. That's after 5 years of having a clean record, but that's another area we can discuss in another day. But now we've gone through this process. So you're saying it's an absolute requirement, and this is what's important. An absolute requirement, if you're going to take a plea, don't take that plea until you find out what the COBS is for the plea.
Absolutely, Barry. I don't know how many times I've seen when I've been in courtrooms waiting for my case to get called, I see other defendants appear before a judge and are in total shock when they get the sentence they get. And it's usually because the lawyer hasn't requested a COBS evaluation and it's kept a surprise until the time of sentencing. That's a very, very serious problem from my perspective in the criminal justice system, and leads to a lot of clients very upset about filing legal actions and grievances against their lawyers because it wasn't fully explained to them the sentencing ramifications that can occur. A COBS evaluation can protect that.
Okay. The other important part of this is once you enter a plea, if you want to appeal, your rights of appeal change after the plea is entered. Isn't that true?
Yes.
Okay, I want you to explain that, because this is why it's so important to know what you're facing up front. Because once the plea is entered, you do not have an automatic right of appeal. Is that correct?
That's correct, and it's different with each court system. I know we're not going to get into an in-depth discussion about the federal system, but there's even appeal waivers and pleas in the federal system. But the state system, once you enter a guilty plea, you do not have an automatic right of appeal. You have a right to seek application to appeal, but that would be at the discretion of the higher court, the Michigan Court of Appeals, as to whether they wanted to accept your appeal or not. If you go to trial and lose, that's an automatic right to appeal, and the Court of Appeals has to hear your appeal. So
Okay.
you're giving up that right by entering a guilty plea, unless there's a conditional plea. That's a separate discussion.
Let's take a break for a minute. We're going to talk about the ramifications after the sentence and how the sentencing guidelines are established.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
You know, we've been talking all this time about how to handle a case, but I want people to know how to get a hold of you. So give us all the information that we need. Where you're, I know you told us your office is downtown on Gratiot. What's your telephone number?
My phone number is 313-963-0210. Our phone is answered 24 hours, 7 days a week. We're geared to handle any legal problem someone may have.
Now, I got to ask you a real important question. I'm going to get smart about this. When you say our phone is answered, is it answered through the answering service, or do the calls come to
No, it's not. The calls come directly to us. Either my wife, Gabi Silver, or myself will get to you immediately for any call that's made. I've had calls in the middle of the night on holidays. It doesn't matter to me because I know how important it is to someone or someone's family when they're going through a serious legal problem.
Same in my office. On the civil side, we have people that call. In fact, Christmas Eve, I had to call at 7 o'clock on Christmas Eve because one of the clients had received a communication about going to court. And the call is passed through to me. It rings 4 times, 5th time comes to me. So no one's in the office. Take the call. It's a better way to practice. If you're going to have a practice, you got to be in touch with your people. So I commend you for being in touch with your people. Now, we touched on an important subject, and for those of you who are just getting up, we've been talking about the prosecution of a criminal case, and it was a hypothetical case where I was the defendant. But I'm going to go to sentence now. And in Michigan, we have sentence guidelines, don't we?
Yes, we do.
And would you explain what sentence guidelines are about, and give us some of the mechanics, David, on how sentence guidelines work so that people understand it's not just the crime that you commit today, but it's what you've done in your lifetime is mirrored in, for lack of a better term, and reflected on the outcome of your case.
Barry, many years ago, there wasn't any sentence guidelines, and there was a concern statewide of the disparate sentences that someone may receive in Oakland County as opposed to the same kind of conviction as a sentence someone would receive in Wayne County or any other various counties. So there was a concern of the wild difference in sentencing by different judges. So the Michigan Supreme Court decided to come up with a formula called the Michigan Sentence Guidelines, which they would try to get equality in sentencing across the board in the state. So they came up with which basically a scoring grid for any given offense called the Sentence Guidelines. There's 2 basic factors to it: prior record variables and offense variables. The prior record variables are as simple as it sounds. If someone has no criminal history, they'll be at the best category. If someone has a very extensive felony criminal history, they'll be in the worst category.
I
It's a
have to
point
stop
system.
you for a second. If I have a juvenile record, is that going to be in the prior record variable assessment?
Surprisingly enough, it will. Even if someone gets a special HIDA consideration in the past, even though it's not a public record, it can be used in the scoring of the guidelines. That's something a lot of lawyers neglect to tell their clients. So the guidelines are very important for a lawyer to go over in very great detail with their clients, and a close look at the discovery materials that we receive from the prosecutor's office. There's many times where a prosecutor may mistakenly believe my client has a prior felony conviction, or in fact it was a misdemeanor conviction. and that can have a big difference in the scoring of the guidelines. The offense variables that we talked about take into account how seriously was someone injured, was the complainant, like in the assault case that we brought up with the beer bottle, did they receive serious disfigurement to their head or their face? Did they have to get medical treatment? Do they have serious impairment of a bodily function? All those can result in higher points on the offense variable guidelines.
On the offense variable guideline, is there a section on there for emotional injuries?
Yes, there is. Surprisingly enough, if someone is receiving, if a complainant or victim is receiving professional treatment, therapy, psychologist, points are added on against the defendant for that. If the victim's family is receiving special treatment or therapy, that can add on points for the sentencing guidelines under the offense variables. So it's very important for a lawyer to go over that carefully and not be surprised at sentencing as to how high the guidelines can get.
Now, under the federal system, and we're shifting gears here, do we have sentencing guidelines?
Yes, there are very detailed, complicated guidelines in a federal case that are far different from the state case. It's like going from a simple jigsaw puzzle that on one level to a very complicated one for the federal level. And one of the more interesting things that I found with the federal guidelines is, although you're not punished by going to trial, you're rewarded by entering a guilty plea with a 3-level reduction for acceptance of responsibility, which I always look, the flip side of it, it really is saying you're being punished if you go to trial and lose. You also can get punished by the federal system if you take the witness stand as a defendant and the judge makes a later finding that you've misrepresented the truth or lied on the witness stand. That can be a further punishment under the federal sentence guidelines. The other difficulty in federal guidelines is there's so much ramification in terms of, in fraud cases, about the monetary value involved can sometimes called relevant conduct, can cause those guidelines to go up also.
Now, on the monetary side, the fraud cases, though, you're entitled to a restitution hearing.
Yes, you are, and especially in both levels. And I see that quite often. I do that in many cases recently in state cases. We have, even after sentencing is over with, we later on have a restitution hearing. And that, what a restitution hearing is, it's like you show us, prosecutor, to a certain level of proof that in fact these damages are honest monetary damages, because it can affect someone who, for example, who goes to prison. They will take money out of your prison account if you have an outstanding restitution bill.
Good morning. Hello. How are you?
Yes, hi, how are you?
Terrific. Welcome.
I have a question.
Go ahead.
Yes, my question was, okay, if you had your defense attorney and they didn't do all the things that you discussed during, before your trial, and now it's up to your trial, and you're not feeling comfortable, what recourse do you have?
Well, that's kind of a loaded question. You have to break it down a little more. What didn't they do? And Mr. Cripps, he's a specialist.
I mean, they said they were going to get some more evidence, gather the evidence, get some more things together, but none of that has come to fruition.
That's a very common question, and it's a good one. If it's prior to trial, you always have the right to get another lawyer, get the lawyer of your choice.
Okay.
And if it's after a conviction and on appeal, then that's something that can be looked at as to whether effective assistance of counsel was given during the investigation and trial of the case.
But you have
okay.
You have to be very careful, because if you say it's evidence and the evidence was discoverable or available and accessible and it wasn't obtained, what's the problem?
Well, the problem in terms of it has to be shown that it would change the outcome of the case, and there's also, if there's something that's newly discovered, these are different techniques a lawyer can use to get a conviction set aside.
Now, in terms of effectiveness of counsel, I'd like you to explain this.
Okay, well, thank you. I'm going to hang up and listen.
Effectiveness of counsel. Let's
Well,
talk
the
about
United
this.
States Constitution and the Michigan Constitution under the Sixth Amendment require that each person charged has a lawyer who gives them effective assistance of counsel. I always interpret that as meaning not only giving 100% to my clients, but also exercising every avenue of investigation I can for my client. There's some lawyers who shouldn't be doing criminal defense work. I've seen that. They don't look at proper defenses. They never look at the fact if someone has a severe psychiatric history, and there may be some psychological defenses, and many lawyers don't look at that avenue. I've inherited cases where I've got a conviction overturned by doing that.
Good morning. Good morning.
Good morning.
We're on the air.
Hello.
Hi, how are you doing?
I can't hear anything.
Well, can you hear me now?
I can't hear anything, Bear. I know you're there, but I can't hear you.
Well, call me
I'll
back.
call back.
Okay.
So it's important to look at every avenue for all the defenses that may be out there before you enter into a guilty plea, for example, or before you make that big decision of going to trial. You don't want to miss any big defenses.
You know, I can remember times as a young lawyer going through the neighborhood just to find out who the witnesses were and talking to them. And when I heard the witnesses' story, I tell my clients, this is what's going to happen if you go to trial. And it was totally different than what I was told by the client. So it works both ways. Are you back with us? Good morning.
Good morning.
Can you hear us now?
Okay, I can't hear anything, but I'm going to ask my question, then I'll look at TV just for the answer. A CCW holder that has a bullet that was used in a crime found by the police, is it the police job to inform the other attorney that that bullet has the CCW holder's name on it, and that this is evidence even if they don't find the weapon? Thank you.
Another good question. I think what you're touching on is if there is discovery by
Come on, y'all.
law enforcement of exculpatory evidence, evidence that may clear someone in a crime and is not properly turned over, and the defense later discovers that, that's a big issue. And I've seen people serve many years in prison before exculpatory evidence is discovered sometimes. So that's something, once it's brought to a lawyer's attention, can be of great use in terms of overturning someone's conviction when they've been wrongfully convicted.
Good morning.
Good morning. My name is Miss Turner. I was watching your show, and I have a legal question, a criminal legal question. Once it's a case that involves two people going somewhere. I can't be specific on air, but one did not know this other person had a weapon. Something occurred where there was murder, and this young person did not know that she took another person to the store, not knowing that she had a weapon. Something happened. So she's being charged as if she knew that this person went out to actually commit a homicide. And my question is, she went to her lawyer, her mother went to the lawyer and asked for them to file an appeal to separate the case. And the prosecuting attorney doesn't want to do that. They want to try both of these cases together. So appeal was placed, a motion to appeal was put forward, and they denied that appeal for it to separate the trial case. And they want her to take a plea of 20 years. And My question is, what is the next alternative step?
We'll give you your answer. Go ahead.
Yeah, you covered a lot of ground there, but it's what as I understand the scenario here, someone may be charged an accessory to a crime. However, they may not totally have understood what the other person had in mind. In our criminal justice system, someone should only be punished for what they have mental approval, agreement, or understanding. If someone else commits a crime and they weren't aware, the person with them weren't aware they were going to do that, that's not right under our criminal justice system. The other issue I heard you talk about has to do with a request to have a separate trial from the main principal in a case, or the accessory doesn't want to be tainted by the evidence against the other person. There is something known as a motion for severance or separate jury. The principles there are most judges want to have just one trial because of judicial economy, and most judges don't want the complication of having one or two or three juries at the same time because it's more difficult to try. However, a lawyer has to be a zealous advocate in explaining to a court that their client will be tainted and harmed by evidence that would be admissible maybe against the main actor that would not be admissible against the aider and abetter. There's a lot of case law. We have to in support of your request, back it up with the facts, argue how it's unfair, you wouldn't get a fair trial, and it absolutely should be appealed and preserved as a issue. I'd rather, representing my client, always have my own separate jury from any other co-defendants' juries, because I want to address my jury. It's my group. It's my people who I want them involved in my client's culpability or lack of culpability. And I don't want it tainted by what other lawyers may argue on behalf of their client. At trial, each client's lawyer will fight for their own client and may step on the toes of the other lawyer or the other defendant's rights in the zealous advocacy of trying to get an acquittal for their client. So the system allows the right to have a separate fact finder, a separate jury, a separate trial under the right circumstances, and that's something that should never be overlooked by a lawyer in terms of wanting to win your case.
We're going to take two quick calls. Good morning.
Good morning, Barry Keller. Happy New Year to you.
Thank you. Happy New Year to you.
Thank you. Thank you. To your guests, I'd like to know if I am witnessing, if a person is witnessing a crime, like an assault or something happening to someone, or say we see an old man being beat up or something, if we don't say anything or do anything, is that a crime legally?
Okay, we'll give you a quick answer here. Happy New Year to you.
Excellent question. That's been the subject of a lot of litigation and analysis over the years, whether there's a duty for someone to report a crime, whether there's a duty for someone to step forward and make a police report, whether there's a duty for someone to get involved. There's a lot of good Samaritans who have gotten involved, and there's been ramifications for that. Quick nutshell answer is there is no duty from a criminal viewpoint, from criminal charges, of someone having to step forward and report something to the police or becoming involved as a witness in the criminal justice system. There's a lot of other slight possibilities of, depending on how deeply someone gets involved or their knowledge of the situation, but someone as normally cannot be charged with a criminal charge for not stepping forward, for merely witnessing something.
One more time, tell people how to get a hold of you and your dear wife, and I'll have her on the show next time.
Thank you, Barry. She certainly is the brains of our outfit. Our number is 313-963-0210.
Have a great day and stay warm. Thanks for listening.
Thank you, Barry, for
Bye-bye.
having me on your show.
Thank you.